Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your hosts, Kirk Pendergrass, John Gentry, and Chris Hallett.
What's happening, everybody?
Good evening, folks. Welcome to Kirk's Law Corner Live. Christopher Hallett, John Gentry, and myself. And, of course, our producer over there, Ted Fogg. We love you. Thank you very much.
Love you too, bro.
We got a couple different things we're going to do tonight. John Gentry is going to do a screen share, and he's going to show some stuff on Title 42 federal lawsuits, how to file your civil lawsuit. Just kind of a quick rundown there. I'm actually going to go over what's going on in our nation, our country, with our president, and what's really going on in the background. Because I think people need to get informed about what's actually going on. And then what's all this other stuff that's going on out there? Oh, Trump this and Trump that, and he's going to get impeached. And no, that's all a big facade, scam, parlor tricks to try and hide what's actually going on. They're going down. It is coming. And I'm going to show you some documents here that's, I've put them out there. I've told people, here's the proclamation, here's the executive order. I'm pulling them up right now. So when I do the screen share here, I can just switch between the three that I have. Plus, I'll even show you some of the Jeff Sessions stuff. I'll show you some other stuff here that, you can use this stuff in your filings, any of your filings, whether you're in criminal or you're in family court, whatever. Because this all really boils down to human rights violations and human trafficking. So we need to understand what all that really means. And I want to welcome Chris and John to the show. If you guys want to do any of your opening statements over there, got anything while I get this set up over here?
Oh, right now I'm just sharing to the kids group, just letting them know that we're going to be covering current events tonight. So if they've got anything going on in school, they can take Dad to work with them, and we'll go over current events for them. The liberal teachers might not like it, but hey, it is what it is.
So I'm going to do a little segment tonight on how to file a federal complaint. And in this process, it's not just the how to run through the process, but also how to navigate around I call them the nuances, which are all the little tricks that they try to use to keep pro se litigants or sui juris litigants out of federal court and wrongfully dismiss our cases. So I'll share some of those tricks with you guys and show you how to get around them.
I'm actually just going to pull up on PDF here. Let's see, which mouse do I have? All right, okay. Close that. Yep. Do some sharing. Let's get this stuff out there, because this is going to be something you're going to want everybody to know, including John Gentry stuff here. So I'm going to try and get on here on my other machine.
Yeah, I think every time I get on this show, I always learn something from Kirk and Chris. And I love Kirk's work. I always learn something about the history of our law and where it came from. And Chris is just so good at nailing down at the process and what's wrong with the process. So I always learn from these guys every time we get on here as well.
It's the science of the process.
It is.
Man, is it complicated. But you're talking about 56 of some of the smartest men who ever lived that constructed all of this.
Right.
So, I mean, to say that it's, you know, it's stupid or outdated or whatever, to go through it as it's written, I mean, it's literally impregnable. There's no, if you follow it as it's written, see, there's the difference. If you follow it as it's written, there's no way. That's why I said the thing will run forever. It's just, you know, everybody trying to throw their bar monkey wrenches into it and selective practices and all of that, you know, happy horse pucky crap, you know. It's like, yeah, okay, whatever.
Yeah, I don't know. What is something about that as it is written?
Yeah. In plain English, you know, that's why I said my favorite question nowadays is like, dude, did you go to law school? And if you did you pass?
That's the one I was trying to remember. My saying is, oh, you went to law school? Obviously, they forgot to teach you the law. You ought to go back and get your money back.
Yeah. Oh, dude, I'm such a bad influence on you. I should have never told you that.
I have a great story about that, just as an aside. So I got into court, and in a previous hearing, counsel had asked for a directed verdict, and the court gave it to them, of course, because the court was like really one-sided. But I came back in another hearing, and I said, you know, that directed verdict was issued in violation of the rules of procedure. The rules say that, you know, before a directed verdict, there must be cross-examination before they, you know, you can call for a directed verdict after a plaintiff presents, and you can say, you know, I've given you all the proof, and I would like a verdict right now. Or it can, you know, if the other side responds, then the plaintiff has to have a chance to come back and respond to that. And I said, you know, this was done in violation of the rules. You know, I didn't get due process. I didn't get a chance to rebut their allegations or their arguments. And the judge said, you know, Mr. Gentry, the rules of civil procedure are very complicated. It's a whole year in law school, and my head is still spinning. And man, I tell you, Chris, I had to bite my tongue. I was like, maybe you should go back and retake that class, Your Honor. Because this is what the rules say. But, you know, you just got to roll. Roll with it.
Right. Why is this? Now it won't do the share part on my phone. Usually it shares pretty easy. New updates. All right. Well, trying to get it out there.
Fatima says, apparently Jeff Sessions, you know, he's suing California. Apparently the case is before Judge John Menendez, same judge who misconstrued my pleading against Sacramento County Court Commissioner. So I said, oh Lord, tell Jeff Sessions, welcome to our world. I mean, that's just, oh man. Good for you, Fatima. Go get them. That's it. Let them have it. Pull a Trump on them and hit them where they live on Twitter. You know, this is the kind of stuff that, you know, we can get out. And when I make my reports and, you know, we do the shows and like that, it's, you know, I've come to a point now where I've started to actually enjoy this. You know, over the weekend, some things came up, and, you know, I had to make a decision. It was time to let some things go and transition from who I used to be to who I am now. And, you know, it is what it is. I'll regroup and attack as I always do. But anyway, it doesn't affect the work. I'm not going anywhere. So don't let anybody tell you, oh, he's quitting. No, he's not. So
yeah, just because you might quit smoking cigarettes doesn't mean you're quitting all this other stuff.
That's right. You had to say quit. You had to say smoking, didn't you? It's all your fault.
Well, you know, I'm just giving an example here.
I love you, bro, but that's all right. We're, you know, right now it's a, yeah, that's true for Beam. I think I do need a break, but right now is not the time. You know, time is to hunker down and, you know, go to work. That's exactly what I'm doing. Getting multiple requests from multiple departments, agencies, committees. They want on the mailing list when I do a follow-up report. They want copies of this stuff, because not only am I citing just what the law says, I'm also citing what the science and the articles of practice are that go with it. So, you know, when it comes to when we take this thing and what does it look like based on what the Constitution says versus the differences of the repugnant mechanism that we call family law today, we can definitively show on paper what's wrong with it. And not just what's wrong with it, but here's what is in law, and this is how we fix it. So it's not just, hey, I'm coming and whining to you with a problem. Here's the solution to that problem. And, you know, that's where we win. It's not going in there jumping up and down and yelling and screaming, oh, my ex was mean to me, and my ex-wife was a bitch, and my ex-husband was a bastard, or blah, 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 blah. They don't want to hear that. They want to hear specifics. What's the date? What's the time? What was said? Who was present? You know, bulleted points. Bing, bang, boom. And that's the stuff that is really powerful. And when we put it in context of, you know, what, like the stuff we're teaching here, you know, American jurisprudence and what American jurisprudence says. I mean, emoluments is just such a very small, minuscule part of that. But it's just the one gear in the cog that we've like skipped over. And, you know, ironically, reading the rules of Parliament, by definition, the rules of Parliament, now I say this all the time, and my interpretation was not only incomplete, but by definition, the word, for them to even talk about it, it's not just that they're not qualified, it's a betrayal to everything they swear an oath to under the bar, under Parliament. So that's why I say when you look at our government structure, the person who we have to prosecute, which is that parliamentarian, we don't have somebody in there, which is loss prevention in the way we practice that today, which is all of American jurisprudence, which is the missing piece of the puzzle. So when I did that live feed on the board the other night, that was directed at Congress. Again, you know, that's a piece of the puzzle that's been missing. And I just said, look, this is where we've been deficient. And I take it all the way back to the War of 1812. And that is right there at the time period where that mechanism, that check and balance, was not completed properly. And we fell off of that wagon from the War of 1812. That's where it started. So, and that's the case I'm making before Congress. And it's just that simple. So it's not about anybody's fault. It's just, nobody took the time to actually go back through it and look at it and go, well, yeah, there's obviously an anti-bureaucracy clause in here somewhere. And how do we handle that? Well, here's how we handle it. And so, and that's the good news, is because Congress will be protected against repugnant legislation if two things happen. The first one, obviously, is the current mechanism. Can we prosecute them for this? And that's, you know, obviously no. But yes, we can prosecute you for lying. Okay, so yeah, that's what parliamentarian has said. Loss prevention hasn't even been consulted, not in 230 years. So all of those things with American jurisprudence, and we can see this, how it filters all the way down to the lack of public defenders, right? So when you get down from where we are in the federal government, the State Department and how it's built to deal with foreign governments and like that was built, but nothing else down to the people was ever finished. So that's why we have these big prosecutors' offices, and we only have this little tiny mechanism that's incomplete from American jurisprudence, and it's filled in with these bar attorneys to be public defenders. Well, that's not the way the science of the practice was written. So when you read the American jurisprudence, it was the prosecutor is supposed to prosecute. It's like you've got one job. If we got a bad actor, we unleash the Kraken on the bad actor. That's what you're there for. But as far as the governance is concerned, by not having that internal spine, that internal mechanism to manage all of those things and make sure policy and procedure is within the law in American jurisprudence. I mean, you know, I went my whole life and just went right over my head too. So don't feel bad. It just took, you know, this problem to come full circle again to figure it out. So with that, I'm going to hand that off to John, and let him help you guys get started on where you start with filing your federal complaints.
Okay, thanks, Chris. The process of filing a federal complaint is not difficult, and I think it is so important. We have a constitutional right of due process, and there is no due process anymore for the most part. It's repeatedly violated. You know, we're not provided our right to be heard. Decisions are based on perjury. When it's proven perjurious later on, there's no enforcement of the perjury statutes. We're not allowed to present our evidence. I mean, there's just a long list of rights violations that go on pertaining to due process. So we have to stand up for that. Our attorneys are not going to bring disrepute to the judiciary and question the actions of any judge. So the only way that we're going to enforce our right of due process is if we do it ourselves. And I want to show you guys it's not that hard. So I'm going to share my screen with you here and run through some documents and what you need to do to get the process started. So I think the first thing is to get access to PACER. PACER is the Public Access Court Record System. I did a quick Google search just to keep you guys from getting tripped up. This is a company that's selling access to PACER, and access to PACER is free. And you look for www.pacer.gov is the proper website. And I put a link to it here in my document just to give you guys an idea of what the website looks like. And so you just click here and sign up for an account. You don't need to pay anything up front. You do need to provide a credit card. And if you start downloading documents, it's 10 cents a page, which sounds like a lot. But for any one document, they won't charge you more than $3, no matter how many pages are in the document. So sign up through PACER, and you have to monitor your case because they're gonna, if you're going after a bad actor, a judge or a legal professional, they're going to do everything that they can to deny you due process and get your case kicked out of court. And so you have to watch your PACER account and watch everything that's filed on the docket on a daily basis. For when you the first things that you're going to do when you walk into the court is you're going to present them with a complaint and a summons. And we'll probably do a separate show on how to construct a complaint. I'm going to run through some of the essential elements tonight. But basically, you're going to walk in there with two documents: a complaint and a summons for each defendant in the case. And to give you an example of what this looks like, here's from the U.S. District Court, and you get this summons off of the district court website. So you just do a Google search for your district court. These all look pretty much the same across all the districts, and you'll see one here called Forms, All Forms. And then you scroll down and you'll see a summons in a civil action. And so if you're suing for a right of due process, that's a civil action against a judge or perhaps an attorney. And this is what the document looks like here. So for each defendant, attach a summons to your complaint. You're going to walk into the clerk's office with a complaint and a summons for each defendant. The clerk is going to do it. Usually they'll do a raised seal or at least a colored stamp on the summons. Then you take that summons along with the complaint and provide a copy to the defendants. If you're suing a judge, you need to take a look at your state-specific rules. In Tennessee, I'm going to do a quick Control-F and look for Attorney General. So if you're serving a lawsuit against the state or any agency or any person, you have to provide notice to the Attorney General. This is similar across most states. And this is one of the things that'll get you kicked out is improper service. So, read through your state's notice procedures. This one is off of my Tennessee Rules of Civil Procedure, but you'll find the same thing in your jurisdiction. After you serve them, when you serve them, and this is in that same rule, when you're serving the state or a state agent or a state agency, Tennessee allows you to serve by certified mail. Not all states are the same. They may require personal service. Whether it's by personal service or in Tennessee, we can file by certified mail. You have to go back and provide the court with proof of service. If it's personal service with a person who serves summons as a job, they'll fill out an affidavit and say, I personally served this affidavit. I swear by it, and da 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 da. If you're doing by certified mail, I wrote up a little just proof of service document, and in here I included service on the parties, copies of the summons, and then this is a copy of the green card that you'll get back from the post office when you send out certified mail. And so you'll take that proof of service and bring it back to the district court or mail it in and say, here's my proof of service. I want to go into electronic filing just a little bit, because I think pro se or Surrey jurists, when you're representing yourself, we're often denied in many district courts the privilege of filing electronically. And it's so unfair because electronic filing is free. So you don't have to pay for all that postage. You don't have to notice the parties. They get notification through the electronic system. You don't, it saves you.
You don't have to notify them? You don't have to send out a notice?
Say that again?
You don't have to send out a notice to them?
No, and I'm gonna show you a trick about that.
Okay.
So the first thing you do is if your court does not allow electronic filing, do a motion for electronic filing and say, it's not fair that I'm denied equal access to the court. More than likely, they will say, well, you've got to attend CMECF training. CMECF is case management, electronic case filing. I'm going to show you a picture from my class, and I'll tell you the reason I'm showing this picture. notice all the desks, and these are set up, all of these desks, when the class started, they were all full. Now, the district court says, well, you have to be an attorney to file electronically. I can tell you there were probably about 3 attorneys sitting in that class. Most of them were young attorneys from state, working for the state attorney general's office. The rest of them were all paralegals, 20, 25 years old, you know, maybe not even college graduates. So it's a fallacy that you have to be an attorney to get CMECF privileges. So throw that in your motion for CMECF filing privileges and say, this court well knows that paralegals are granted privilege to file electronically. And so I would like that same convenience as well. Now this is, Kirk, to answer your question, this is, or just to step aside a little bit, this is a copy of an email that you receive when documents are filed electronically. Now, as pro se litigants who are not granted CMECF, we don't get this email. You know, we get, sometimes we may get a letter from the court, probably not. You'll get notice by mail from opposing counsel. And maybe if they're extra nice, they'll send you a copy through the email as well when they file it. When you file, they get an electronic email. This comes out of the electronic system saying, hey, this document was filed. But here's what's more important, Kirk, is in here, there's a link to click on the document. You get that for free. You get a copy of the document for free. You don't have to pay for it. And they have a note here to public access users. It says, Judicial Conference, the United States policy permits attorneys of the record and parties to a case, including pro se litigants, to receive 1 free electronic copy of all documents filed electronically. So for them to say, no, you can't have CMECF is denying you that same right that the attorneys get, and it's denying you that free download of the document, which is unequal access to the courts. Now, what I did is I sent an email to the parties, and I said, hey, by the way, I noticed that the attorney for the state said that notice is going to be provided electronically to the attorneys in the case. I would like to do that same thing. And I said, you know, if you're all agreeable, I'll put this on my notice of service. I hereby certify that a true copy was filed with the clerk's office personally and will be filed electronically by the clerk's office and served through the electronic system. And so in doing that, then it gets rid of all the mail expenses and all the paper and all of the ink. And that was a tremendous cost savings to me, to not have to mail copies to them, to not have to pay for the ink and all. And when I say pay for the ink, my documents are really long sometimes.
John?
What's that?
When you put stuff on the screen there, make it as big as you can so everybody else out here can see what you're looking at there.
Can you see that?
Yeah, that's way better.
Okay, so this is just, this is just the email I sent to all the opposing counsels in my case and said, you know, hey, are you guys cool if you're just noticed through the electronic system? One of them was kind of a jerk about it, but all the rest of the attorneys were like, yeah, that's cool, you know, and it saved me a ton of money to do that. So I encourage you, you know, motion the court for CMECF. And then talk to the opposing counsels and say, hey, I don't want to notice it by mail. I'm getting notice of CMECF anyway. What's the use of wasting the paper? Are you guys cool? And so that was a big advantage for me. And just to give you an example, this is the document that I received from that attorney. And so she said, you know, I hereby certify that the foregoing was filed electronically and served to the electronic filing system too. And then those were the other counsels in the case. And then she said, you know, served by first class mail to me. And I'm like, let's get rid of all the first class mail, guys. You know, let's just do this. Let's just do this all electronically.
This is an interesting point. I want to jump in here real fast, John. Every time you run into somebody that pulls something like this is going to be your trouble spot in every case. And 99 times out of 100, the rest of the people on this list, they know the problem. They're agreeable to it, and they're looking for a solution because guess what? They got a whole metric crap ton of other clients waiting for that same answer that we're ready to give them. So that said, when you get a troubled person like this, this is one of those obstructionists that we were always talking about. So these are the ones you got to watch. This is usually your motion hog, right? They're going to file for motions to extend time. They're going to file ridiculous 12B motions. They're going to file all kinds of objections and attempt to enter facts that are not in evidence, and so on and so on and so on. So just so you guys know how you can pick out that troubled practitioner in the very beginning, this is the spot right here. So anyway, I just wanted to throw that back out there, John, in case anybody
thanks, man. Thanks for
went over that.
You guys, please do anytime. I love your comments. So moving on with this, the first thing, and Chris just touched on this, you're going to get a motion to dismiss. So here was the motion to dismiss, and it just says, for these reasons, real short, and then they'll attach a memorandum supporting their motion. And this is generally a longer document referring to all the case law. Now, these guys do my research for me. They're like my paralegals. I love them because they come in here and they'll reference and say, well, because of this case here, this thing should be dismissed. And then I go in and read that case and I'm like, well, that's not really what that says, but that case will reference a whole bunch of other cases. And they do all of my legal research because then I open up, and we're going to do another show for you guys on how to do research later on. But I look at these cases, and in that case, the Supreme Court that they're citing, or the other higher court that they're citing, will include in their opinion other cases as supporting authority. And those other cases are where you get your arguments from. So it's a really great strategy. But more important, what I wanted to share about this in getting a motion to dismiss is looking at the Federal Rules of Civil Procedure, Rule 15A1B. And so under 15A1B, it says, if a pleading of one to which a responsive pleading is required 21 days after service of a responsive pleading, or 21 days after service under a motion under Rule 12B, whichever is earlier. This is a key point that anybody who's doing a federal complaint, you got to know this rule, if nothing else, because they're going to come back and say, well, you didn't state a valid cause of action and you should be dismissed. And here's why you didn't state a valid cause of action. They're telling you what you need to do to perfect your complaint in their motion to dismiss. And you got 21 days to fix your complaint and refile it. And you don't have to ask permission. You just say, here you go. Pursuant to Rule 15A or 15A1B is my amended complaint addressing all of their BS motion to dismiss. This is probably my favorite rule in all the civil procedure is this one right here. You guys got to know 15A1B.
Okay, hold on one second, John. I'm going to jump in here real fast. There's a difference between, if you want to put that back up there real quick, there's a difference between the word amended and the word supplemental. Okay, if you look at Rule 15 where it says amended and supplemental pleadings. Now, an amended means you want to take out the one that you had, okay, and put in a new one. If you don't want to do that and you want to add to the one that's there, and depending on the way the motion reads, your 12B motion reads, it only may just require a supplement. So you're going to say, according to Rule 15, as a supplement, meaning in addition to the original complaint, citing the deficiency cited by counsel, here is the requested information. as cited in the 12B motion, whatever. So just so you say, remember, this is word salad, right? So don't get tripped up on the word amended, meaning take the whole thing out and replace it with this, or supplemental, meaning, hey, I'm going to take this and put it right on top of that. Okay. So, or underneath it, either way. So just like I said, I wanted to drop that in on there because there is a difference. So consult your local rules when doing that, because sometimes it's in your local rules as well.
And a follow-up point on that, another great use of a supplemental pleading is when further crimes and rights violations have occurred. And so, this under 15A1B is to you can restructure your complaint, you can add defendants, you can drop defendants, you can do whatever the heck you want with an amended complaint. With a supplemental pleading, another great advantage to that is to say, oh, hey, by the way, there's these new crimes. These guys keep going even though they got a federal lawsuit outstanding.
Yeah. Right.
And so that's a great way to use a supplemental pleading later on is if they continue to violate your rights. You bring in facts. And I'm not sure. I would have to go do a little research on whether you need leave of court to do a supplemental. I don't think that you do. I think yeah. Okay, great.
No, you don't.
Another thing there is when you, let's say you're in the middle of your case and you decide to go to federal and file that federal lawsuit. You can actually, as soon as you file the federal lawsuit, come back over here to the other case that you actually filed the suit on and amend your pleading. And all your pleadings there, you have to put in there that there's no other case pending or there's no other da. Well, now you need to amend your initial pleading because there is a case pending. Okay. So, and that would actually have to happen after you get a case number and that they've accepted your filing.
Right. So be careful of that because they're going to try to trip you up. Right. And the trip up on that is, how does this tie into the original complaint? How does it tie into the original transaction, occurrence, or event? So what you have to do is you have to basically state in the progression of events. Okay. So in other words, yes, this event we're talking, or transaction, wouldn't have happened now if this first thing hadn't happened first. That's how it applies. That's why it's relevant to where we are, and that's why it should be allowed on this case. So that's why I said there's things you have to kind of, know and understand, and that's one of the reasons I'm here. I'll help you get through that stuff.
Okay, so, never mind.
If I can bring up this case real quick on here. So this was my case in federal court, and I'm gonna refer back to this in a minute. But one of the first orders that I got in the case was this order, where the court referred me to the magistrate judge. Magistrates, man, I think the purpose of magistrate judges is to facilitate the case, to take workload off of the district court judges. But what I found, and my impression is that they're gatekeepers. They are there to get rid of you. And they don't have to follow the rules so much because they're not a judge and they're not going to be held accountable as a district court judge would. And so these guys allow them to get rid of you, maybe violate your rights a little bit more to try to get you kicked out of there. But she came in and she said, this judge said the case is exempt from initial disclosures. So initial disclosures means that when you file a complaint, the defendant is supposed to come back and say, well, here's where all the evidence is. And you can find that under Rule 26, what the requirements are for the defendant. They're supposed to say, here's where we keep the records, here's where all the evidence is. But they say it's exempt, that this case is exempt from initial disclosures. Well, I used that against them. As soon as they exempted me from initial disclosures, that means I can request discovery without having to go through a scheduling conference. So I use that against them. They came in here and they said, this one really, really scared me. They said the clerk is directed to send all copies of orders entered in this case by first-class mail only. And this only is what really gave me pause for concern. So I filed a motion for clarification, and I said, does that mean I can't walk into the clerk's office and get a copy? Does that mean you're only going to serve notice to me to first-class mail and the clerks can't give it to me? Now, here's why this gave me cause for concern. In another case, I had sued a judge. He just violated my rights. I didn't want any money. I just said, I want to do over. This guy, he really just ran me through the ringer, violated my rights left and right, but I just want to do over, and I want the court to order him to adhere to the Constitution. That would be nice too. And
right.
In that case, that magistrate issued a report and recommendation to dismiss my case and did not provide notice to me. And I'll show you how this is a different case. But if you look here, when I filed this case, they have certified mail receipt and green card returned. So what that means is when the court issued this order saying that the case was referred to the magistrate, the district court properly sent me certified mail saying, here's the order. And it was done with return receipt. And when the green card was received by the district court, they entered it into the record. That's the way it's supposed to happen in a pro se case. They're supposed to send certified mail, and they're supposed to show these green cards to prove that the pro se litigant got a copy of the order that was issued by the court. Now let's go back to that case against the judge. All throughout that entire case, whenever the court sent an order, there was always that certified mail, green card return, saying we sent it, he got it, here's the proof. In that case, all throughout the case was, certified mail, green card return, certified mail, green card return, except for the R&R from that magistrate to dismiss my case. Here's why that's important. If a magistrate issues an R&R to dismiss a case and a district court judge accepts that R&R and you don't object to it, you're pretty much done and you can't even appeal. The circuit courts have ruled that failure to object to a magistrate's R&R and then going to the circuit court it's skipping the appellate process. You're skipping over the district court judge and you're going straight to the circuit courts. And they use the word may be grounds for not granting appeal, which in pro se language means this is grounds for not granting appeal. And they're not going to give you a chance to be heard in the circuit court.
Right.
So going back to this order, when she said only, they knew in the other case that I watched the docket. I look at the docket every day, and I'm going to go over that with you guys in a little bit. But they knew that I watched the docket in that case by the judge. So I don't know for sure, but plausibly, Chris, would you agree? Plausibly, the intent was to issue another R&R, not provide me notice, and then I go into the clerk's office to get a copy, and they say, oh, I'm sorry, we can only provide notice by first-class mail only. You can't have a copy.
Yeah, that's what I would read into it. That's why I said you got to be real careful with their word salad. One word can make or break, through the procedure. And this is when I talk about the science of it. This is where it gets real tricky.
Yeah, I don't know that was the intent. I'm just saying, it's plausible, and that's what it looked like to me.
Right. But it does say unless otherwise directed by the court. So that would be, Johnny on the spot. Well, what do you mean only? So let's get the court to direct the clerk that I can come pick up a copy directly.
Yeah, so I filed a motion for clarification, and I said, does that mean I can't get copies from the clerk's office? And she also said, so I went over. She said the case is exempt from initial disclosures. She said it's also exempt from customized case management pursuant to this local rule 1601 B2D. Now, most people will look at it and say, oh, darn, this case is exempt from customized case management because of this local rule. Go read what the rule says. And what that rule says is that any case in which a litigant appears pro se is exempt from customized case management. Chris, what is that? That's unconstitutional. Kirk?
Exactly. Correct. So basically what they're doing is they're taking these local rules and they're just creating them arbitrarily, right? This is an example of a bad guidance document, right?
Yep.
So when we talk about the difference of the articles of practice, these types of local rules are all guidance documents, every one of them. They cannot be added to the judicial side until they're okayed by the Supreme Court of your state, right? But what they're doing is they're just arbitrarily throwing these rules out there. They're not even taking, I guarantee you that rule has not been presented to the Tennessee Supreme Court.
Oh, I'm going to challenge this rule in the United States Supreme Court. And I'm going to ask the United States Supreme Court to instruct them to get rid of that, because
don't be surprised. Don't be surprised if they tell you to also, if they request you may cert into the state Supreme Court for a review of the local rules to find out.
That's a U.S. District Court rule.
So it's federal.
Yeah.
Oh, well, then the Supreme Court, then SCOTUS can rule on it.
Yeah, so I'm going to ask the U.S. Supreme Court, please tell them to get rid of this rule because it's discriminatory. Now, for the viewers out there, what is customized case management? Customized case management is to provide efficient and cost-effective proceedings. So when a judge is assigned customized case management, the judge is supposed to facilitate scheduling hearings and say, okay, you guys need to provide discovery by this date. Let's get together and talk about when discovery is going to be provided. When are we going to have an evidentiary hearing? When are we going to do all of these different parts of due process, right? Now, for a suri juris, and for the viewers out there, suri juris just means, I'm kind of responsible enough and intelligent enough. I can handle my own affairs. I don't need somebody to help me present my case. I can do it on my own. And so when I say suri juris, that's what I'm referring to. So for them to say, somebody that's pro se or suri juris doesn't get the same customized case management as a legal professional, it's so discriminatory. The courts are supposed to make reasonable accommodations for pro se suri juris litigants. The courts are supposed to they're supposed to liberally construe complaints and assist pro se litigants. These guys do the opposite. They do everything they can to deny due process to us so that the courts can have their monopoly in the legal profession and deny us justice. That's what that rule is about.
They're supposed to be amenable to the people, not to their cloney club members over there, members of the bar.
So when they say, just because they reference a rule or they reference a statute, don't just go, oh, darn, I'm exempted, rats. Come back and say, go read the rule and ask yourself, is this constitutional or not? Because I have found so many rules in state court, in federal court, district court, federal circuit court that are completely unconstitutional. and I'm gonna challenge them. Now, when you challenge a rule like that, now you have standing in the circuit and Supreme Court. Now it's not just your case about you. Now you're expanding it to the constitutionality of due process being not provided. Mm-hmm. So, if they come up with crap like this, challenge it. Another thing I did, I noticed that the state asked for an extension of time to file their response, and so this is a copy of a motion for extension of time. Just a really short. Hey, I'd like some more time. Generally, these things are granted non-proton, and in this case, it was. In fact, here can you still see that? Okay, Chris.
Barely.
So.
But yeah, okay, that's a little better.
Okay, so what the court did is they stamped the document, and the magistrate judge signed it. The motion D11. When she says D11, that's docket entry 11, and that's down on the. This is 13. It's the order, but their motion was document 11 down here at the bottom. So she just stamped it, right? It's granted, and I'm like, yeah, no big deal. That's fine. So I filed a motion for extension of time, and this is a trick me. I shouldn't say trick me. These are, I call them nuances of the court system, and these nuances are tricks that you have to navigate around. But let's call them nuances and be respectful to the court. So I filed a motion for extension of time. A couple key things I want to point out here. So I'm moving for additional time to file a response to their 12B motion and to file an amended complaint. Kirk, how many documents am I asking for an extension on? It's two, right? A response to the 12B and an amended
response to the 12B motion and to dismiss. Yeah. Motion to dismiss and to file an amended complaint. Yep. So two different.
Two documents. That's pretty clear, right? Mm-hmm. I reiterated that point. Plaintiff respectfully requests just 10 days is all I wanted, and I'll file an amended complaint, and plaintiff will also file a response to defendant's 12B motion to dismiss. Again, Kirk, how many documents am I asking for there? Two, right?
Just the two.
And I said it twice, didn't I? I said up here, I'm asking for two documents. I said down here, I'm asking for the same two documents. Can't be more clear. This thing's one paragraph, right? One paragraph.
Yeah,
right?
pretty simple.
How do you screw that up, right? So here's the order. Now here's the question. Why isn't my order just stamped at the top like theirs? Why did they take time to write an order? Question number one. Here's the order. It says presently pending is a motion to dismiss. Plaintiff shall have until March 31st to file a response to the motion to dismiss. Plaintiff is advised failure to timely file a response may result in a recommendation to dismiss the case. Okay, so you granted me my motion to file an extension of time on the motion to dismiss. What about my amended complaint? I asked for two documents twice. Why the only single document is approved for extension of time? I don't know, but the intent looks to me to be that when I file my amended complaint at the same time, past my normal deadline, oh, sorry, Mr. Gentry, you weren't approved for an extension of time on that document. We're not going to enter that into the record. You don't get to amend. Could that, Chris, is that plausible?
Well, that's why I said, they completely skipped right over top of your request to skip for the motion to amend the complaint. So,
do you think?
Yeah, the simple fact of the matter is you can say, okay, that would be response to order dated, whatever the dated order was, See attached response to Mode 12B motion. In the response, plaintiff further requests the potentially overlooked question of the amended / supplemental extension of, or the request for extension of time with respect to the amended / supplemental complaint. Now, that's how I would handle something like that. Well, I don't know how you did it.
And I did something very similar. Here's the document. So plaintiff's motion for clarification. And I came in and I said, hey, I asked for 2 documents, but I only got an answer on one. Mm-hmm. And am I approved for both of them? And so then she came back and she said, well, Mr. Gentry's original motion for extension of time is granted, therefore his motion for clarification is moot. Which again goes back to the question, why didn't she just stamp mine like this the first go around? Why did she take the time to write an order and then only grant me an extension of time on a single document? The courts should maintain an appearance of impartiality at all times. And what that looked to me is like they were trying to dupe me into filing my amended complaint late for the purpose of denying entry into the record in violation of my right of due process. That's what it looks like to me. I don't know. I complained about it in federal court. Let me move on. Enough of that one. Actually, I think that's about all I had, and I've been talking a long time. So those are just some of the initial process. Later on, we will go through how to construct a complaint, the essential elements of a complaint, and I'm going to just touch on it really briefly, real quick. That's under Rule 8. Is what's in a complaint. Now, what's interesting here is this is just a very simple explanation of what's necessary in a complaint. Plain statement of the grounds, plain statement of the claim, and a demand for the relief. That's all you got to do. But that's not all you got to do as a pro se litigant. Ours, they're supposed to construe our complaints liberally, but instead they hold us to a higher standard than an attorney. And any little nitpicky thing they can find wrong with our complaints, they will. So later on, another show, because I'm getting kind of talked out on this one, but later on in another show, we'll go through on how to construct a proper complaint that will get past all of their little... Go ahead, Chris.
I'm going to drop in a little thing. Pull up Rule 28. Just scroll up to Rule 28C.
28C?
Yeah. I'm going to give you guys a little trick on something that we actually used in one of my cases that actually, believe it or not, did work. Because we showed the judiciary, not only were we not trying to attack and, basically make them look bad, we found something and we're bringing it to the court's attention, and it doesn't matter that it was in favor of the other party. It was an issue that impugned the integrity of the court. And here's how we showed them. There it is right there. 28C, just a little bit further up, John, or a little down.
There?
Right there. Yep, there it is. See disqualification? Here's what we said per that rule. We said, look, here's the situation. All of the actors on the other side of the room at the other table, every one of them are attorneys. And we had one of the attorneys was still attempting to represent the client, who was also a defendant in that case. And we said, citing this rule, that impugned the integrity of the court. So we showed the court, not only are we wanting equal representation and fair play under the law, okay, wow, we also said we recognize it for the other side. And because we did that, we got some pretty hefty answers. And I'm working on the supplemental report for that right now, and that sucker's going to be a monster. But this was the case, and this was the rule that we used, and it made it very, very, very difficult for that judge to dismiss that complaint and basically say, okay, look, here's what you got to do. So it wasn't that it was dismissed. We got the template from A to Z in that case. And that's exactly where we are right now, which is the reason I'm doing the supplemental report. And I'm going to expect a whole metric crap done of jumping up and down and yelling and screaming from that state bar. But you know what? I don't care. I'm immune from prosecution now, so good luck with that. But the simple fact of the matter is you come out and you can show the court that, look, this is not me standing here seeking revenge, okay? Because what's the difference between justice and revenge? Well, if you want revenge, you're just going after your ex and you don't give a rat's ass about the court, about anybody or anything. But if you can walk in there and say, hey, look, not only do I recognize this as an integrity issue, I'm going to show you one, and I'm not even the one that benefits from it. Look to our left and tell me what you see. And you know, it leaves them to the point where they're going, oh my God, these people are really getting screwed. And they will give you the exact template on what you need to do, excuse me, and how you need to do it in your jurisdiction, citing everything from the rules to the case precedent they'd like to see you use. Also show you a good way to write the argument by referring to, hey, look, this is what law firm, you know, ABC lawyers did. You may want to go and check this complaint out here. Go, no, wink, wink, nudge, nudge. So if you show them, look, I'm willing to work with you, and we're going to do everything we can to do that, they will work with you. And that's the thing that we're getting through now. And this is the barrier that the bar, ironically enough, is trying to put between us and the judges. They're trying to put that barrier in there, and we smashed right through it. So because we did that and we showed them, look, dude, this is not just us standing here yelling and screaming. You know, we're just, you know, we want to help you out. You tell me what you want me to do and I'll do it. And so that's why I said this is going to be an couple of interesting cases of when you see these rascals come out. So anyway, I just wanted to point that out as a way to defeat their the attorney's attack on you of, oh, you're an idiot, you don't know what you're doing, you can't interpret the law, you don't know anything about the rules, blah 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 blah. You know, their favorite argument. So you walk in and you say, oh, hey, look, by the way, yeah, we can, and here's where it is right here in this room, and it's making you look bad. And you will get a response that will help you. So, like I said, you know, if you find yourself spiraling out of control, you might want to look for your rules, something like Rule 28, to be able to show them, you know, hey, look, I'm not just being a jerk here. I'm trying to help you out. In addition, because I understand the importance of maintaining the integrity of the court. So you can prove that. You just earned yourself some respect with that judge. So in light of that, go ahead and we're off to Kirk because he's got a lot to cover.
All right, ladies and gentlemen. This is the update of kind of like the history here of what's happened since December with our current administration and government. Okay, so we're all ready for this. Now, we've gone over this proclamation before, but putting all this stuff together, it gives you an idea of what's really going on. So this proclamation, you know, it proclaims, it's kind of like a declaration, basically. Okay, and this came out December 8th, 2017. Now, if you'll notice this, okay, December, okay, the first real thing that came out was Jeff Sessions on November 16th with the kibosh on the use of guidance documents. But see, Christopher Hallett's been over there in in the courts and dealing with that and the Congress and all that stuff with his emolument stuff since January of 2017. So there's kind of a back history to some of this. And I'm not going to say that it had a direct effect on it, but I wonder where they got the idea. Let's just put it that way. So here's the proclamation. Our great country is forged in the fires of a revolution to overthrow the rule of a tyrant by a free people who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence to the Constitution and through the Bill of Rights, our country and our people have always known the true God-given nature of liberty and the ability of law to safeguard it against the state. For 226 years, the final piece of this freedom-sustaining bulwark, the Bill of Rights, has formed the bedrock of the constitutional protections every American holds dear as their birthright. Okay, now if we understand what that actually means, what that means is the rule of law has just been reestablished. I've gone back and I've read some of the other proclamations done by other presidents, and this is something that's relatively done by every president. Sometimes every year they'll redo this proclamation, but none of them say anything about the Declaration of Independence, nor the Constitution, let alone the Bill of Rights. Okay, the big one is the Declaration of Independence. You know, like I've said before, I was down there at my local courthouse and pulled this right out of my bag, and that public defender down there saying, well, no, Declaration of Independence ain't law. Well, I don't know. I'm going to tell you that it is. I don't care. Back to whatever school you went to, you might want to go get your money back because they didn't teach you what the law is. That's why we're doing what we're doing, because they won't teach you, so somebody's got to. So we got to read it. On Bill of Rights Day, we recognize the importance of the first 10 amendments, and it's actually not amendments, but I'll let it slide, to our Constitution, to protecting our liberty and freedom against the inevitable encroachment of government. Our founding fathers understood the threat of expansive, omnipresent government. From the beginning of our republic, therefore, they endeavored to enhance the Constitution with the Bill of Rights, a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. You know, this is something I kind of argued with the last few days, a couple different people. You know, we're talking about fundamental principles of law. When we go to the law of nations, I kind of made the joke of that's kind of like the fundamental principles of law itself. When you talk about law of nations, how to create a nation, each and everything is a law of its creation. So declarations actually lay down the law, and then constitutions in our style and form of government, we use constitutions. Okay, that actually lays down. It's not laid down, it's ordained and established. Okay, so constitutions are ordained and established. And all that does is provide the process for things that can be brought into being, which goes back to a legal maxim, a repugnant act cannot be brought into being. So if it's repugnant to the fundamental principles of law, it's repugnant. Oh, where'd you go, John? Crap. Are you still watching, John? Did we lose him? Oh, well. Okay, so on June 8th, 1789, James Madison, originally skeptical of the need for a Bill of Rights, which is not true because we'll let that one slide too, introduced into Congress several amendments to the Constitution that would eventually form the Bill of Rights. During the ensuing debates, Madison told the Congress that because all power is subject to abuse, it was worth taking steps to ensure that such abuse may be guarded against in a more secure manner. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please, the right to speak our minds and consciences, you know, kind of like make America great again, or drain the swamp, or pull the plug on this shithole, okay? That's your right to, that's freedom of speech. Okay. As long as you're not causing injury or harm or you know, slandering people out there, you have the right to do that. And it don't matter where you're at, whether you're in court or not. Okay. The right to firearms, to protect ourselves and our loved ones, the right to be free from unwarranted government searches and seizures, the right to a jury of our fellow citizens when accused of legal wrongdoing. This is our president, okay? Others, like the right to object to housing troops in our homes during peacetime. What do we have there? Police force? Don't we pay these police forces? That's our tax dollars paying them, and our tax dollars pay for their homes. That's the same thing as quartering people in our homes. They may not be exactly in this home right here, but they might be your neighbor, and you're paying for it. That's the same thing. Exactly. Like the right to object to housing troops in our homes during peacetime are often thought of as relics of a bygone era. And this is exactly that social control that they've been trying to teach people and our students in school and stuff, that, oh, well, this is all just old stuff. This, you know, it's 200 and some years old. None of this has anything to do with today. Lies, 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 on purpose, by design, okay? You can't change the fundamental principles of law. 2 + 2 = 4. Let me know when you can change that, okay? Regardless of their familiarity or applicability to our daily lives, however, each clause of the Bill of Rights addresses profound and real abuses the founders faced, and each is crafted and locked into law to protect us and future generations from their repetition. Okay? Since its adoption, the reach of the Bill of Rights has spread far beyond American shores. As George Washington rightfully said, liberty, when it begins to take root, is a plant of rapid growth. For example, in the wake of the devastation of the World War II, the spirit of the Bill of Rights inspired the United Nations General Assembly to adopt the Universal Declaration of Human Rights in 1948. Now, that's, yeah, universal for everybody else, being ours actually is way better than that Universal Declaration of Rights, but for the rest of the world, no. Just like the Bill of Rights, the Universal Declaration of Human Rights is grounded in the recognition that just governments must respect the fundamental liberty and dignity of their people. By enumerating core rights that should be immune from government encroachment, both the Bill of Rights and the Universal Declaration of Human Rights have helped fuel remarkable prosperity and achievement around the world. Blah, 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 blah. The rest of this is here is just, you know, the last part here I'd like to say here is, I call upon the people of the United States to mark this observance with appropriate ceremonies and activities. Okay? That's the proclamation there on December 8th, 2017. So now we get into the executive order from December 21st, 2017. By the authority vested in me as president by the Constitution and the laws of the United States of America, including the International Emergency Economic Powers Act, 50 U.S.C. 1701, the National Emergencies Act, the Global Magnitsky Human Rights Accountability Act, okay, there's public law, Section 212F of the Immigration and Nationality Act of 1952. Okay, this is dealing with immigration stuff too. Okay, find that the prevalence and severity of human rights abuse and corruption that have their source in whole or in substantial part outside the United States, such as those committed or directed by persons listed in the annex to this order, have reached such scope and gravity that they threaten the stability of international political and economic systems. Human rights abuse and corruption undermine the values that form an essential foundation of stable, secure, and functioning societies, have devastating impacts on individuals, weakening democratic institutions, degrade the rule of law, perpetuate violent conflicts, facilitate the activities of dangerous persons, and undermine economic markets. The United States seeks to impose tangible and significant consequences on those who commit serious human rights abuse or engage in corruption, as well as protect the financial system of the United States from abuse by these same persons. Okay, there's more to this here. I'm going to skip down here to section 6 so that we all understand who this actually applies to, because it says mostly up there, right? Okay, but let's get right into the punch them right in the kisser. Section 6. For the purposes of this order, okay? A, the term person means an individual or entity. The term entity means partnership, association, trust, joint venture, corporation, group, subgroup, or other organization. And the term United States person means any United States citizen, permanent resident, alien, entity, organized under the laws of the United States or any jurisdiction within the United States, including foreign branches, key words here, or any person in the United States. So Ken Scott and you guys out there, if you're still watching, you should be able to pick up on those key words there and understand what that means. Okay, first the entities and foreign branches. Okay, this applies to everybody other than the people. Okay, this is talking about governments, our government and the rest of the world, all of their governments, because there's plenty of different governments out there. But because it's affecting our economy because of the International Monetary Fund, the bankers, you know, the international bankers that out there have taken over the entire world. You know, some of these, what I will call false flags, because that's what they are, that we're attacking these other nations and other countries, is because they didn't have an international bank. So the international bankers weren't controlling their money. Now, if you didn't know that, you do now. So the reason why some of those, when we're down to, I think, 1 or 2 nations that are left, okay? That's all that's left that isn't under this international banking cartel, because that's what it is, using debt notes, Federal Reserve notes, and trading, everything goes through them. So now, the rule of law has been reestablished, established that even the United Nations, or Universal Declaration of Rights, it's the United Nations Declaration of Rights is what it is. It's in the back, actually, it's over at my house. 9th edition, Black's Law Dictionary, right in the back of it. That's that Universal Declaration of Rights. It says United Nations. So while I don't think it's a really good idea being part of the United Nations, now that things have changed a little bit, it would actually be nice to be part of the United Nations, and we'll just clean up the whole world, okay? We'll just get rid of this crap, this shithole all the way around the world. So let's jump to the next one if I can get to it.
Hey, can you scroll back up to that statement about devastating impacts on individuals? Yeah, right.
Persons listed in the annex are reached.
Yeah, this is I quoted this to the Sixth Circuit and the Supreme Court and the District Court, pretty much everybody, because this is the same argument that I'm making in federal court about corruption. It has devastating impacts on individuals. It weakens our institutions that are supposed to provide us due process. It certainly degrades the rule of law, and it undermines economic markets. And I want to touch on that real quick. Typically, what you find in many cases, certainly not all, I think in the child abduction, child kidnapping, wrongful taking of children by Child Protective Services, you know, that's a whole nother animal. But often what you find is high earning individuals are targeted in these cases because they got money. And who better to extort from than people that have built lives for themselves. when that happens to a large demographic across this country, it contracts the whole GDP of our entire country. And it's just getting worse and worse and worse.
Mm-hmm.
That was a really profound statement that President Trump made, because it's exactly, before this order came out, I made exactly these same arguments in the district court. And then I quoted him in the Sixth Circuit and into the United States Supreme Court. So I just wanted to jump in and share that, Kirk. Thank you.
Mm-hmm. So, yeah, you know, I mean, this is obviously a serious question. Who does this apply to? Which I kind of just went over in section 6. Everybody. This applies to everybody in the whole entire world. More specifically, if you're an agency, I don't know, an entity, that would be an agency. So like Child Protective Service, social services, you know, to try and talk to some of our people. But more specifically, like international drug cartels, international bankers, okay? Big time, that, you know, that's affecting our money, our economy, because they mess with the stock market. They met with the LIBOR, okay? The LIBOR rate, I don't know if you understand what that is, okay? That's the interest rate on loans, okay? So when they start messing around with that, I mean, just a few points one way or the other in the interest rate can affect your property and the economy of a whole nation. So you have to understand, Trump is a businessman, longtime businessman. He understands all this stuff. This is like second nature to him, just like half of this stuff is second nature. The loss prevention part is second nature to Chris Hallett, okay? So he gets it just like that. And, you know, when I'm not going to say Trump did all of this himself. He's got help, but he ain't no dummy like a lot of people out there try to make him out to be, okay? He's smart. I've listened to him during his campaign, and again, little words, just two little words there. I know what they mean, okay, because I've done my research, I've done my homework for a long time. So you have to understand who this actually applies to, and it's everybody. If you're an entity, any kind of private corporation, okay, CPS, did you guys know that? That's a private corporation. Do you know some of these prisons are private corporations? They're owned privately. They're supposed to be owned and controlled by us, we the people. We're the ones that's supposed to lay down the law, not a private corporation running their own private prisons. Human trafficking. That's human trafficking, folks. They're getting paid. That falls back to the emoluments. They're getting paid to incarcerate these people on crimes that are not crimes. If there's no victim, how do you figure that it's a crime? Not only that, some of the felonies that they put out there, that doesn't fall in line with a heinous crime of being a felony. It has to have violence in order to be a felony, you know, or, you know, major human trafficking, acting in interstate commerce and that kind of stuff. So this is going to be the kicker right here, okay? 2018 amendments to the manual for courts, court martial, okay? Now, what this is, okay, John, you I don't know if you know about this or not. I'm pretty sure you do, as a fellow Marine over there.
I'm familiar with it, yeah.
UCMJ, Uniform Code of Military Justice. Now, when I've talked about this Admiralty jurisdiction stuff, okay? This is exactly what we are being subjected to. And when I talk about we're being told that, you know, this facade, it looks like we're getting due process of law, and some of these criminal cases, you get a trial by jury. No, because that's not exactly how things are supposed to be. You know, the jury is actually supposed to determine whether the law itself is lawful. And, you know, the defendant's supposed to be able to make his argument that isn't lawful, but they deny us all that. And when they do jury instructions, they don't tell them that they have. In fact, the last one I just went to, and I've been to like 3 different trials, and the judge pretty much says the same thing. Oh, it's my job to tell you what the law is, and then your job is to find guilt. No, your job is to be an umpire. Now, that's the next document after this one. But I want to get into this so you can understand what's actually happening. March 1st, 2018, okay? By the authority vested in me as President by the Constitution and the laws of the United States of America, including Chapter 47 of Title 10 of the United States Code, Uniform Code of Military Justice, We'll just skip over that stuff there. Section 1, Part 1, Part 2, Part 3, Manual of the Courts Martial, United States are amended and described in Annex 1, which attached and made a part of this order. Okay, so essentially this right here is saying, and I know some of this says, oh, well, not before January of 2019. Okay, no, only the amendments that have made. Okay, but everything in here is about, it's already been, I think, where was it? I swear it said 1984. Yep, right there. This executive order 12473 of April 13th, 1984, as amended, is hereby ordered as followed. Okay, this is something that's already pre-existing. Trump didn't just pull out this out of his rabbit hat, well, kind of, and make this up. You know, this facade out there, this narrative that Trump's just all crazy and wild and doing crazy stuff. No, he's reading the law. He's using the law as it is written. Okay. So this is from 1984. This isn't something even relatively new. We're talking 30 years ago, 34 years ago. Okay. He is amending parts of it, but the reality is we're supposed to have, everybody is the militia, right? Everybody, every actually it's supposed to be every able-bodied citizen, not just male, okay? It's every able-bodied citizen, whether you're 14 or whatever, you're automatically in the available unorganized militia in the event of a invasion, okay? Now, to be called into service, that would be the draft, okay? That has to be 18 to 45. So I just missed that. I'll be 47 this year, so unfortunately I can't get drafted. But, we're supposed to be self-governed. We're supposed to provide for the common defense. That's in the preamble to the Constitution. So what this effectively does is the military has the power to make arrests, okay? And they have the power to arrest who? Well, wait a minute. Admiralty jurisdiction, right? This is
Article 4, Section 4, Kirk.
What's that?
Article 4, Section 4. Remember?
Yeah, guaranteed republican form of government, and that's exactly what he's doing.
Correct. Well, exactly, and shall protect each of them against invasion, and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. Well, what the hell do you call a school shooting?
Right, but this has all been in plans for quite some time. This doesn't have anything to do with the school shootings, and I can address that here.
I'm just making the point, right?
Right. So, and that actually, we could tie that in right here, right now. Yes, because let's face some facts here, folks. Have you seen the kid, the actor, the crisis actor? He's been in 3 different state school shootings. Take a good look at that kid. Go back and look at some of the other school shootings. How in the hell is that kid in 3 different school shootings? Pull up his name, do some research on him. There's another gal out there. She's also a crisis actor. She's been in several different of the crisis shootings. Okay, these are called propaganda. And there's actually a congressional act out there that says our government can use government officials to create propaganda, and they can murder people for propaganda reasons. This is exactly what you're seeing. Okay, this is to cause civil unrest, to divide the people, to go, essentially, they know, the deep state, they know that they can't take this country by force. Okay, there's just way.
Can I just put an opposing opinion in there, Kirk? Just really quick.
Sure.
I have seen some stuff about crisis actors being on multiple locations, and we have to be careful because it is so easy to manipulate video these days and to insert people that may not have been there, so you have to be a little bit skeptical about video where they're saying, this kid was here and he was here and he's a crisis actor, therefore, because that video could have been manipulated. Not saying
no. They're straight out coming out and coming on the news media and saying, yeah, I was there and I saw this and we're not talking about planning somebody there.
Yeah, the only thing I'm saying is we have to be careful about, relying on content on the internet out there because it can be so easily manipulated. I'm not saying it's not true. I'm just saying we have to be.
That's why I said go look for yourself. Look into that stuff. Go. Wait a minute. This kid was here. This kid was here. This kid. That's the same freaking kid at 3 different shootings. How is that possible? How are you standing there talking to a cameraman about this crisis that just happened in 3 different locations? Get around a lot, huh? They always seem to happen where you're around. And not only that, you might want to check on his age. How old is he? Why is he in school? But neither here nor there. So back to the Uniform Code of Military Justice and the, protecting us from invasion, foreign and domestic enemies. This is what the military is actually for. And so Trump has basically said, guess what, guys? We're going after the people. And all the bad, go back to the executive order for human rights violations, serious human rights violations, and human trafficking. This is exactly what this is all about. That's why all of these pieces here come together. When you put them together, you understand the bigger picture, because that's what's happening. And that is the reason why our current president is being attacked left and right about this, that, and the other. It's all, contrived. I'll use one of your words there, John. It's all contrived. It's just it's a distraction, which is fine by me. You guys keep looking over there. You guys keep doing all that over there, because this is what's actually happening in the background. Okay. So they're going after FBI agents, DOJ, CIA, it may trickle down and get into CPS. I mean, nobody is untouchable.
Agency, right?
Yeah. Alphabet agencies, BLM, Bureau of Land Management, not Black Lives Matter. Over there on the East Coast, you guys don't really hear much about BLM, but over here on the West Coast, it's kind of like the FBI out on the land. And then you use the EPA, Environmental Protection Agency. Oh, well, this water is protected over here. And then, Hillary Clinton and her Uranium One stuff with Russia. You ever take a look at the West Coast map over here and just do a quick search for how much land the federal government claims that they own over here on the West Coast. And it's just like a huge swath down the whole West Coast. There's not much left on the West Coast that's not owned, allegedly not owned by the federal government. And you go clear over past my state, and it's just a huge swath right down through this West Coast. And there's actually lots of minerals in there, and one of those minerals is uranium. Okay, so gold right now, I think it's like $1,400 an ounce. Okay, uranium is like $70,000. Ready? A gram. So ounce, 1,400, like $60,000-$70,000 for a gram. You know how many grams are in an ounce? Anybody? Do that math real quick. Let's see. 3, 6, 9, 14, 28. It's like 64, isn't it? 64 grams.
Class, anyone? I don't have my calculator on.
28.3495 according to Google.
Okay, so 28 for an ounce. Yeah.
Grams per ounce, 28 grams per ounce.
So 28 times $60,000-$70,000 will give you an idea of, in comparison, for an ounce of gold versus an ounce of uranium. Why Hillary Clinton made that deal with Russia? Because that's lots of money, big time money. Okay. So, you know, you talk about Russian collusion. There it is. That dossier, however you want to say that word there, that it's already been proven that the guy that wrote it came out and said that he was paid by the DNC. Okay. This is true stuff. It's already out there. So here's the next one. How do I get that out of the way? I'm going to have to minimize.
That's where the original 13th Amendment comes in, ladies and gentlemen.
The bar?
Right?
Oh, what was I going to do?
No. The collusion with foreign entities, right? That's
Right.
why they're trying to see. That's why they're going after Trump, trying to create this Russian scandal,
Yeah.
because they're literally him of all of the shit that they're doing. So
They don't have anything. They keep grabbing at straws. That's basically essentially what it is. So
they're trying to, and this is the great part. This is kind of like my standing joke about the case against like Bill Cosby. Whatever you think about him is irrelevant, but when you read the charges, it's like they've accused him of living in the 60s, the 70s, and the 80s. Well, what was that? Sex, drugs, and rock and roll. Guess what? Yeah, all 3 decades. You just nailed it.
Yep.
But anyway,
Okay.
I digress. I just thought that was hysterical when I first read that.
Now let's get into this so we understand some human trafficking here and how this applies. So, what is the definition of human trafficking? According to federal legislation, the Trafficking Victims Protection Act of 2000, TVPA, and its subsequent reauthorizations, human trafficking is defined as a sex trafficking in which a commercial sex act is included by force, fraud, or coercion, or in which the person induced to perform such act has not attained 18 years of age. Okay, that's the most common thing when we think about human trafficking, right? But there's this second section here. The recruitment, harboring, transportation, provisions, or obtaining of a person for labor or services through the use of force, fraud, or coercion for the purpose of subjecting to involuntary servitude, peonage, debt bondage, or slavery. 22 United States Code 7102, Section 9. Okay. And actually, we can go right there right now. Just pop
Sounds
in
like
here.
a good definition of family court garnishments.
That's the thing. It's not just family court, guys. This is every single freaking court. Traffic court, criminal court, family court, probate court. It's all embezzlement. All of these people are paid to do this to us. Those entities, the bar is an entity.
Right.
The bar
And
is
that's the reason I was showing that scale.
So all
right?
you bar attorneys out there, if you've been involved in human rights violations and human trafficking, you might want to check around.
Because let me show you what the parliament scale looks like and why it's repugnant to our form of government, right? I don't know if you can all see that.
What was that? Title 28.
Chris, wait till
The
Kirk comes off the screen share. We can't see.
Yeah. Oh, okay. Well, we'll do that in a minute, because that is the parliament scale, which we declared independence from. And ironic that, these tricks are so new again. That's the hilarity of the whole thing. And the motivation behind it is what it is. And we can talk about ideology and social control versus domestic tranquility and where those ideologies actually come from. And we'll actually have that conversation one of these days, just not tonight. So, but we're talking about the mechanics of how they're doing it. So this is what I said. So don't try to look forward into progressiveness, look backwards into history, and you'll find every answer that you need. So Anyway, I just had to lob that one out there while you were searching.
Oh, 7102, I got it backwards. Or not backwards, but 7102. 71029. So right there. Definitions. I'm pretty sure that's probably going to be pretty much the same exact what it just said in there. Yeah. The recruitment, harboring, transporting provisions, obtaining personal labor. Okay. Sex trafficking. There it is right there. State Task Force, United States Victim. Severe form of trafficking. The victim of severe form of trafficking means a person is subject to an act of practice described in paragraph 9. You know, either one of those. So, you know, I mean, force, fraud, right? Fraud. This is all freaking fraud. Involuntary servitude. Okay. Like me, they take away my parental right without due process, without cause of action to take that away. The only way you can take away fundamental rights supposed to be is by trial by jury. Okay. So for them to arbitrarily in family court take a parent's fundamental right away and then over here say, well, because we're doing this and you don't have custody of your child, you have to pay. That right there is involuntary servitude and is a debt slave.
Yep.
Through fraud, debt bondage, till that child is 18 years old, or if you're still in high school after that, blah, 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 blah.
And you got the double whammy.
Bondage. Look up peonage. That's also in there. Okay. Latches is the other one. You got the double whammy, Kirk, because not only did they do the original, what you just got done saying, they're trying to hold you to terms and conditions of contract they don't have. Yeah. We were never married. There's no marriage contract. That's okay. Article 1, Section 9, or is it 10? Article 1, Section 10.
10.
Okay. There shall be no law impairing the obligation of contracts. This is where they get us. Okay. So what they've done is constructive fraud with the birth certificate, the social security number, your driver's license, your bank cards. Take a look at all that stuff. Your name is written in all capital letters on every single one of those documents. It's called the straw man, the artificial person. Yep. So are you the person? Are you the person? No, I'm not the person. I'm a man. Man as in mankind, not as in male or female. So, again, back to this stuff right here.
Word salad. More fucking word salad, right?
Yeah. Let's call it what it is.
Yeah.
It's human trafficking. You've turned us into this artificial person so that you could traffic us. Slavery.
That's called unlawful attornment.
Yeah. Unlawful attornment, which goes back to embezzlement and emoluments. If you actually, here, I'm going to pull that one up because that's a good one. It says emolument right in it. Title 18, subsection 643, United States Code. Actually, did I have that one?
While you're looking for that, I'm just going to comment real quick. Is that okay, Kirk?
Yeah, shoot. Embezzlement and theft.
There's a gentleman in Colorado that's brought a RICO case under the Title IV entitlements, and he's really drafted some strong legal arguments and digging into the language of Title IV. You know, the intent of that law was to combat the problem of deadbeat dads, and I think that's fundamentally, I think there's nothing wrong with that. You know, that if somebody parents a child, you have a responsibility to take care of them. But when you look at this from another perspective, you know, a kid comes to a parent and says, "Hey, can I get this motorcycle?" And you're like, you know, I can't really afford that. No, you can't have it. But what they do with these with the child support payments is they say, well, you got to give them the motorcycle whether you want to or not. And the purpose of Title IV was when parents are not providing any support, then the state has to go in. But if a parent is providing support, you know, according to their own judgment, under Title IV, the states really don't have a right to go in and order it. Now, the states have even gone so far, and they'll impute income, and they do all this other stuff to maximize the most possible amount that they can get out of the parent in order.
Hold on a second there, John. I'm going to back you up.
Yeah.
The enactment of Title IV was a repugnant act, and it can't even exist in our form of government.
Right.
Because for them to walk into your life and make the judgment call of your parenting skills or your how you provide for your family, they don't have that right. Never did.
That's jurisprudence, volume 15,
government.
Civil rights, subsection 2. Natural rights, civil rights have nothing to do with the establishment, support, or management of the government. Kick rocks.
You. Exactly.
Okay.
So that Title IV is a repugnant act, right?
Yep. That is a repugnant act. Okay,
Correct.
so I know this is one of Chris's favorites too. And what's funny is I'm going to read this, and I'm going to go back over here to 1776 and read from 1776. Okay. 18 U.S. Code 643, subsection 643. Okay, that's chapter 31, subsection 643. Accounting generally for public money. This is where we go to disbursements from the Department of Treasury. If you're an employee of the government, you receive disbursement funds from the Department of Treasury. Okay. Whoever being an officer, employee, or agent of the United States or any department or agency thereof, having received public money, which he is not authorized to retain as a salary, pay, or emolument, fails to render his accounts for the same as provided by law, is guilty of embezzlement and shall be fined. Where'd the fine go? But we'll fix that. Under this title or in the sum equal to the amount or the money embezzled, whichever is greater, or in prison not more than 10 years, or both. That makes that as a felony. So this is what I was talking about, how they changed the code. That's gone. They used to say shall be fined, blah, blah, blah. The fine used to be there. All of it, Title 18, subsection 241, 242, you go, the normal ones that used to be 250,000, if it involves kidnapping or death, it was 500,000. Okay, those are all gone. But now it's Title 18, 3571, which has already been there before.
Right.
But they moved they actually redid 3571 as well. It's just lined out straight. Felonies are $250,000. Where am I at?
Let's say, I don't know.
I got to go back.
Kirk,
no.
Your mouse is going bloop.
Yeah, I got to go one more. It's in criminal procedure.
Right.
Fines, 3571.
Sentences.
Yep. Then we go into subchapter C, fines. Okay, sentence of fine. This is, when you say fine, this is actually the damages. Okay, so there it is. For a felony, not more than $250,000. Boom. So if it's a felony, 1 year or more, if it's 1 year or less, it's a misdemeanor. So for a misdemeanor resulting in death, not more than $250,000. For a Class A misdemeanor does not result in death, not more than $100,000. So for a simple misdemeanor, you're looking at $100,000 in damages that are owed to you. So if an officer walks up to you and says, hey, do you got some ID? And you say no, and he harasses you, that's a misdemeanor right there. You understand that? That's an arrest without cause of action. Mm-hmm. But I want to go back to that 643 there. We go back here to Section 4 of the Virginia Declaration of Rights as the theoretical foundation of government, that no man or set of men is entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public service, which not being descendable, neither ought the officers of magistrate, legislator, or judge to be hereditary. That's from 1776, folks. That word emolument, hey, Our founders knew what it meant. They put it in the Constitution. They put it in our ideology. It's declared right there. It's laid down as the law. We can't do that. We can't pay somebody to trespass the law and human rights violations and human trafficking. We cannot pay people to do that. That is embezzlement in and of itself. Just that part is embezzlement. All right. Where are we at here? 9 minutes.
Okay.
Run it, Chris.
Huh?
Run it.
Run it. Well, while you're doing that, I'm going to go ahead and shift over here. And when I was doing my research into the parliamentarian, I'm going to hang on a minute. I'm going to go back to somebody swapped my screen on me. Hate it when I do that. What happened? Did I break Zoom? Nope, there it is. Okay, can you read that okay? Can you see that all right?
Hey, Ted, can you make just Chris's camera full screen? Thank you.
I only need this just for a second. So when I was doing
for about 10 minutes.
Yeah, when I was doing the research on the repugnant scale, okay, this is actually what family practice is. This is what it actually looks like. It's based on the equity scale, which is a hanging scale, which that fulcrum is usually right about there. But what the actual scale looks like because of the attornment process is this. This is the parliamentary equity scale. This is one of the things we declared independence from in 1776. So when they brought admiralty jurisdiction back onto the land, they brought this and snuck this in there with them, right? So because we haven't had anybody in Congress to advise on American jurisprudence that says, oh, by the way, that is repugnant to our form of government, and it does not, we can't do that, right? So that's what I stumbled across when I started looking into who the parliamentarian is and what is his or her role in Congress. Well, you've got one job. The parliamentarian's job is to prosecute bad actors. So this Fourth Crown Temple Bar, and their Lord knows there are people out there with so much knowledge in that history. Rexton Lotus Justice, for example, is probably by far one of the most knowledgeable people on it that I've talked to, and she's just amazing. But I can tell you right now, that is stuff we can't do. It was in our Declaration of Independence. That was, as you said, Kirk, laid down, ordained, and established. And that's why when they said the significance of, people, they want to say, oh, I want to see the money. What's the money trail? The money trail is like a very minuscule part of what emoluments actually is. We're talking it's any advantage, profit, or gain. So it could be anything from real estate subsidy or securities. It could be diamonds and jewels. Oh, excuse me, the uranium one deal. I mean, and so on and so on and so on.
We'll give you 500 million if you let me buy that uranium from you.
Right. Exactly.
That would be
that of course is
because of their condition of employment.
Right.
Office.
Right. Because that position is an inherited emolument. That's the seat that they sit in, right? Mm-hmm. And that's using that position of authority to unjustly enrich themselves. And that's one of the things that we pointed out in one of the cases that I worked. I won't say which one, but when we successfully pointed that out, it was, oh shit, we have a huge problem. And yes, it is repugnant to our form of government. Here's what I want you to do. And that's what I'm doing right now. So by buttoning up these follow-up reports, it is the basic building blocks. Remember, I showed you building that extra leg that hasn't even been there. It's been kind of a crutch, doesn't even exist. We've been hopping around on one foot for 230 years. No wonder we can't find our ass with both hands. So, we needed the other leg, that State Department. That's there, right? It was created to manage these agencies through American jurisprudence. Fiduciaries. We're the only ones qualified to work that equity scale. That parliamentary equity scale, get that the hell out of here. That's done. That's gone.
Yeah.
So that's the significance of what I've done. And yes, I've pissed off more than a few attorneys. And you know what? I don't care.
Right.
My name, address, and phone number is on every one of these documents. I invite them. You want to go toe-to-toe with loss prevention? Let's do it. Bring it.
Well, just to recap, this country, nation, and around the world, it's coming.
Yep.
If you're an entity, down to the individual, okay? Not just the clowns at social services. The reason why we have Hardwick versus Freakin is because people actually think that they can lie, and the three panel judge, three judge panel over there in the Ninth Circuit Court of Appeals, Supreme Court, are just literally just like, I cannot believe you're saying that it's okay for you to lie, and that you actually need case law, stare decisis, to tell you that you can't lie, to take away a parent's fundamental liberty interest, a right that's so sacred of a right. You need clarifications that you can't lie to do that. What happened to the 9th commandment? Thou shalt not bear false witness. I'm not trying to force religion upon anyone here, but that's a fundamental principle that we're taught as a very young child, that you can't lie.
Right.
Okay. There's a difference, and here it is. Okay. Hey, honey, do these pants make my ass look fat? Okay. For every man out there that's girlfriend, wife, whatever, you don't even have to look. You already know the answer. No, you look great, honey.
That's right.
That's different.
You had to go there, didn't you?
Right?
You had to
There's
go
a difference. There's a lie for necessity, for survival.
I'm just going to say that's survival.
Becky, look at her body. It is so big.
There's a difference between
She looks like one of those
and taking somebody else's rights away. Okay. Sorry. You have to seriously think about morally and ethically. Just a tiny scale.
Oh, dude.
You can't lie to take away someone's rights.
Well, even one of our fundamental principles, a maxim of law. The law punishes you.
Let's put it in the chaos.
Yeah, go to your room.
I'm putting that question in the Tennessee Supreme Court right now. Does not perjury lead to chaotic proceedings? How is a court supposed to render fair decisions when he doesn't know whether or not the person is lying? Because the states no longer enforce perjury statutes. Material perjury, aggravated perjury is a felony crime, and the state and the state courts just okay. So I'm asking the Tennessee Supreme Court, is that a violation of equal protection if I'm a victim of perjury and the state does nothing to enforce it, to protect me from the law? I don't know.
Right.
I'm just throwing the question out there. We'll see if they answer it.
Jessica, Alexander, you're talking about doing research on CPS and stuff. Go look on Dun and Bradstreet. It's all registered. They're all private corporations. Every last one of them. Your local police, municipal police departments, they're all private corporations. Everything. Ever since 1871. Okay? Ever since 1870, well, technically, I guess we could go to 1933 to be exact. But since 1871, with the bankruptcy, everything got transferred over, right, to the United States, that private corporation in trust. So, I mean, every single thing, Department of Health and Welfare, the Environmental Protection Agency, they're all private corporations.
Yeah. Boy, and we got a whole friggin' word salad. They're bringing them all out now.
Right.
Bar Association. Tanya says, guys, really? Okay, yeah, I admit. All right, I fell into that one. Ha ha, you got me.
So the reality is, it's all constructive fraud because it's repugnant to this.
Right.
Plain and simple. Every last bit of it is constructive fraud.
Right.
You parliamentary tricks here. It's all freaking tricks. Read that Declaration of Independence.
Yep.
Read the Declared Acts of Tyranny. And here, I'm going to send you back in history again. First, that's the Declaration for the Causes and Necessity of Taking Up Arms. That's where our Second Amendment originated from. That's July 6, 1775. Then the Virginia Declaration of Rights, June 12, 1776. Then the Virginia Constitution, June 29, 1776. And then the Declaration of Independence, July 4th, 1776. And before I forget, the Articles of Confederation.
That's right.
I haven't committed that one to memory. March 20th, 1781.
Right.
17, I think that's what it is.
In the meantime,
it's right here in this book too. But
you've got the Constitution and the shield, right?
To lay down the law of our ideology, ideas, our morals and principles, the fundamental law. And it's based off of the law of nations. If you read the law of nations, which is, again, back to the fundamental law, the fundamental principles of law.
Right.
Okay. The law of creation of a nation. In creating a nation, you have to lay down the law. The way to lay down the law is through declarations.
Right.
Once you lay down the law, then you have to create a process. And that is why the Constitution of the United States of America, in Article 6, Clause 2, says it's the supreme law of the land. Law of the land means due process of law.
Right.
Okay? They mean the same thing. So in understanding supreme law of the land, it is a supreme process of bringing things into being, whatever it is, whether it's the president, whether it's the governor. That's the process. It's laid out in the Constitution. It's ordained and established. This is the process how you elect a president. This is how you elect your governor. This is how you do this. This is how you do that. And the powers not delegated there, they don't exist.
Right.
They're reserved to the people.
Okay? I can tell you, one of the things right now, as far as one of those powers, is the political power. We all have the right to politic, correct? So,
only if you're a citizen.
Right. And, ironic that within that inherent right, when it comes to the science of process, when you can institute a science as a defense, right, that is in line with American jurisprudence. And this is what our system of government is. It's what it's based in. So that's why I said, when I say, when I tell everybody, print this, okay, this is not me asking them. This is me telling them.
Right.
Which is when we go back to that Declaration of Independence. Okay.
Yep.
I don't mind playing the bad guy. I'm enjoying this. You don't even know how much I'm enjoying this. After 28 years to get one back at some of these actors, bring it. Let them come.
Yeah.
So that's one of the reasons why I tell you guys, you can print that and you can quote me on it. If they say they want a signed copy of it, you tell them to call me, or you just private message me anywhere and say, I need a sign the actual signature page. I've already created one. I will email it to you. So that that's already signed and notarized. It's the page, the signature page within the report with my actual blue ink signature on it. So
yeah.
If that ever becomes a question, I just wanted to make sure I pointed that out because I always forget to do that. So
Yeah.
If that ever becomes a question, you just go ahead and hit me up and I'll make sure you get it.
So for all you Uniform Commercial Code diggers and Code of Federal Regulations and, code diggers, it's all constructive fraud. Uniform Commercial Code doesn't apply to the people. That's constructive fraud. That word person, that straw man, you guys all know about that. I've got the Cracking the Code 3rd edition. I've got the Cracking the Code 5th edition. Okay. It's all constructive fraud.
Yeah.
Plain and simple. Drop the word bomb, emolument. Plain and simple. You can't do that. And you're going to still operate in that? No. Can't do that.
Yeah.
We can't pay you to
cut
do that.
Through their word salad.
That's human rights violation. That's human trafficking.
Emolument knife.
You want to bring up birth certificate and you want to bring up social security number and all that stuff? That's serious human rights violations because this affects more than one person. This affects more than just a couple of people. This affects more than just one state. You're talking social security number. This even goes into what they're doing now is even with the immigrants and the refugees, they're giving them social security numbers so they can pull money from title. Well, I don't even know where that one's from. I don't think it's from 4D.
No, it's not 4D. It's
is it a Title 1?
I think no, it's Title 2, isn't it? Or no, Title 6.
Title 6?
Yeah.
But
yeah. So anyway,
this is serious human rights violations. They're turning us. They've turned us all. It's those of you who've dug. The 14th Amendment put us into a serious debt slave. But I'll take you all the way back to the War of 1812. The War of 1812 is what did it. Because in reading those documents that I told you about, especially the necessary for the causes and necessity of taking up arms, okay, that's the declaration for the causes and necessity of taking up arms. You read in there and it talks about admiralty jurisdiction and this ministerial enemy. They couldn't quite figure out who this ministerial enemy was at the time. But they talk about admiralty jurisdiction. It's in the document, okay? Back in 1775. Everything was good with the king. Everything was good with the nobles over there. What was the problem? This ministerial enemy and this admiralty jurisdiction. We want this shit out of here. This does not belong here. That belongs out there on the high sea.
Right.
Get it back out there. Get it off the land and back out there on the high sea where it belongs. We bring the shit onto the land.
Right.
That is what we went to war over. That frickin' bar. And they figured it out in the early 1800s. And that's what the original 13th Amendment was about.
And that is quoted in this amicus curiae. Right. That's quoted in this amicus curiae. Kirk, I just emailed you this. So when I came out, and the first thing I did was demanded a vote of no confidence against the bar, right? And that was the only way for me to go out there and start beating them to death with the emoluments argument. That's why it took me so long to come out, start doing these shows, because I had to do this first.
Yeah.
Because I know the process. I know how it works. That's why I said, doing my job, I've forgotten more about how this shit works than most people will ever know. It's just, I'm using it for my own, to solve my own case, and consequently a couple of thousand-ish of you along the way. So, hey, that's cool. I'll cut the road. You guys want to lay the concrete and paint the lines on it? Have at it. I'm cutting the path. So,
yeah. Well, thank you, ladies and gentlemen, folks, for tuning in tonight, sharing, share, get this stuff out here, especially this one tonight. This one really lays down what's going on. And this food.
These past couple of weeks, we've been really busy.
Clothes, water. Need to make sure you have that. Guns and ammo, because when the crazies out there find out they're going down. And then the liberals and the Democrats and you know, I hate using those labels. Even
well, they are crazy. It is what it is, dude.
It's a world shock.
Yeah.
And I mean, when these people, high profile people, you know, we're talking FBI, DOJ, you know, big time representatives in government, governors, either past or present, you're involved in child pedophilia, you're involved in human trafficking. You know, we may end up with a bare bones frickin' government. Back to self-governed. You might actually have to defend yourself out there.
No shit. Talk me in.
No police. The only thing we'll have is military. And they're going to be protecting the people.
Right.
Not government.
Right.
That's the way things are happening. I know a lot of people, but we've been told this stuff before, and it's a trick, it's a trick, it's a trick. Well, I just showed you exactly in possession of those documents of what's happening.
Right.
I've been following it for a couple of years.
Yeah.
Okay. This is what's happening.
I need to start a hashtag, boot the parliamentarian.
Tyranny is out.
Yeah. Done. Gone.
It's on the rundown. It's coming.
Yeah.
So, John, any last words over there, brother?
Just thanks for tuning in, guys, and stand up for your rights. You know,
that's right.
Get out there and give them hell.
Ted, Nancy Schaefer stuff. What do you got over there, brother? I want you to share that, please.
All right. Let me make sure I'm unmuted everywhere.
Turn your mic stuff on.
Yep.
Or you broke. You're not even able to do that, are you?
Yep, we're good. So, yep, March 25th is the first annual in Clarksville, Georgia, Remembrance of Nancy Schaefer event. It's going to be from noon to 8, but I'll be there very early, you know, as the sun is rising, getting everything set up, making sure the space is all set. The last thing you want in a situation like that is to get there at noon and there's like a 6-year-old birthday party on the space you got a permit for. So in a small town, that's something you want to be careful of. But there is a playground there, and I encourage the local people to come by with their kids and play on the playground. It's amazing. I just want them to know that we're going to be on stage and what we're talking about. And it's going to be family friendly. Nobody's going to be saying the F word or anything, hopefully. I know, like, Francesca's bringing her son, but he's a little bit old. He's 10 now, so I'm sure he knows what the F word is. But we're going to a place where, you know, a lot of us, it's a different culture. If you're in the Northeast or the Northwest, the Southeast, it's a little bit different culture, very Bible Belt-ish. And I think we're going to get a lot of help there through this event. We've got the support of the Schaefer family, their blessing. The Habersham County Sheriff's Department will be there. The sheriff himself will be in attendance. It's going to be an amazing event. And John is going to be speaking there. He's coming to the event and speaking, representing Kirk's Law Corner. So that's awesome. I'm really excited.
I'm too chicken to fly.
Yeah, I'm excited. I'm excited to go down there for that.
Yep.
Not only that, if I get custody of my son, I won't be able to go anywhere.
Thank you for your work and putting that together, Ted.
I'm still working on trying to make sure that I can attend. We got some policy meetings here in Tallahassee. I'm trying to get those all done before the event. So that's why I'm kind of backing and forthing, and I'm not online much these days because I'm doing a lot of those meetings. So
it'd be great if you could show up, Chris.
I'm working on it, brother. Like I said, I got 4 more to do. And if I can bang out all 4 of them and be done, I'll be there. So
beautiful.
I did get their commitment. Their number was 4. So that did come in as of an email this morning. So I was at least able to nail down that many. Nice. And but I guess the only other thing I want to add, I have to add, is just the don't forget our our friends, brothers, and sisters out there that do exactly what we're doing. You know, what we got Sunday, Thursday, Restoring Families Internet Radio with Brian Lee and Steve Paul. And then on Tuesday night, tomorrow night, you've got Far From Normal with Jay Moss and crew.
And live at 5 in promotion of the event every weekday at 5 p.m. Eastern.
Absolutely. And then, of course, we have, last but not least, our producer and awesome. We're going to start calling you our producer in chief.
There you go.
There we go. Producer
We're going to have our producer in chief live at 5 every day, giving you updates. So,
I'm going to let this little cat out of the bag. I got my unsubstantiated claim letter this weekend.
Yay.
All right.
So, yeah.
You got yours too?
Yep. We'll be seeing what's happening here real soon.
Yep. So, on that note, guys, keep up the fight. Keep doing it right. And I'm telling you, we're getting there. We're going to get them. And I'm enjoying every minute of it. So
we want liberty and justice for all, whether you're in family court, criminal court, probate court, whatever court you're in.
Yep.
We're tired.
We're sick of it.
And our president knows he knows. Okay.
Yep.
Like I've been saying for well over a year, I followed Trump in his campaign, and he dropped hints and words and phrases. I know he knows.
Yep.
He ain't a dummy. And here we are in the beginning of 2018, just a little over a year in office, and he's doing it. So wake up, folks, because it's coming. Much love, folks. Thanks for tuning in. Love y'all.
Absolutely, guys.
John, Chris.
John Boy.